Oh,
Oh no, that's
absolutely.
okay, Matthew. You review what you want to review. I don't know about anybody else, but I'm fired up right now. So you present what you want to, and I think you got to come back for a part two because this is a lot. First of all, it's a lot to digest emotionally to realize how evil people. Like I know how evil they are, but this is even like damn, these people are real evil. So let's continue on. Let's continue on. I don't want to cut you off
Right.
because
So the next one. So we've only
Kat's
dealt with,
just Kat wants to say thank you so much for the work and for sharing, Matthew.
you're welcome. We need to get
Oh,
this overturned. If we get courageous judges, we can't fix what happened in the past. But if we get courageous judges, we can set a precedent at the Federal Court of Appeal saying from now on, statutes trump policy. If the employer is breaking the law, you qualify for EI because you have just cause. End of story. It doesn't matter what the template says. It doesn't matter what internal memos say. And I'm going to go through some other problems too. But policies written by people at a corporation cannot trump statutes from Parliament and the legislature of a
nope,
province. And yet
absolutely
that's
not.
the excuse. The policy says we have to do it, so we do. And think about the effect on the HR employee. They don't like it. They're issued a policy that says you have to fire or terminate all these people. I think they're feeling. What happens if they don't fire and terminate those people because they actually don't agree with it? So you're actually extorting employees in HR by saying, if you don't follow the policy, you know what's going to happen, don't you? Follow the policy. And now you're actually coercing employees to violate federal law in order to remove people who are, let's say, causing problems in the workplace for legal reasons, non-compliant, let's call it. Um, so what is the basis? There were 5 cases in case law that showed up in the templates over and over and over again. So I did a breakdown. Relevance. These names will sound familiar if you've had an EI case yourself. Misconduct, McNamara, Lemire, Parody, and Bellavance. Collectively, they show up over 2,500 times in cases, and it's actually way more than that. That's the actual cases they show up in. That's not a footnote count. For instance, these 5 cases showed up more than 30 times just in my case. There's over 50,000 footnote references to these 5 cases. And everything was templatized. So these 5 cases, they had blocks of code in the template generator that spit these out over and over and over again. And it took some time to break down the logic of what was really going on. So these 5 cases, they're all similar. Just a 60-second summary. Bellavance was an employee who worked at a place. He was selling contraband cigarettes at work, which is that's actually a criminal code violation.
It's
He was
legal, yeah,
fired. He was on work property, on work time, in uniform. They fired him.
with
Uh,
valid reason.
yeah, Bishop Benijima was someone who had alcohol problems. He violated his contract repeatedly. He had dozens and dozens of absences per year. He would just take 3 or 4 day weekends whenever he felt like it. They warned him and warned him and warned him for 2 years.
Oh
And finally
boy,
they said, we got to let you go. McNamara
they
and
tried.
Parody, they did. They were very patient. McNamara and Parody were both violating, they were drug test on the job. They worked in the oil fields. When you do a urine test and it shows you've actively got something in your system, like what do you do, right? And then the last one was someone, sorry, Lemire was the cigarettes. Bellavance was working in EI and he was actually giving EI to his friends and family. He was manipulating the process,
Oh boy.
giving preferential treatment to family members and employees. So these 5 cases, I've got the paragraph markers. They all violated the contract over and over and over again. So these are being
And
cited as
these are the cases that
justification,
they used. Yeah, these
right?
are the cases that they used. Yeah, against us.
Yeah, and why is the important point? It took some time to really puzzle this out. Why it's so important. In each of these cases, and kudos to the people who are writing the templates, because as Machiavellian as it is, the ideas that they came up with and make this fly for so long, it takes a particular level of intelligence to come up with some of these justifications to have them stand for so long. It is impressive, the Machiavellian level of what we're dealing with. So in all of these cases, the judge in his decision said, we're not going to look at what the employer is doing. They were all making arguments like, yeah, they should have given me this, they should have done that. The punishment was excessive, I didn't go through progressive discipline. They all made different arguments. In all 5 of those cases, the judge in his decision said, yeah, so you broke your contract. And in each of those decisions, he listed what in the contract they broke and said, look, like you're selling contraband cigarettes at work. That's a criminal code violation. There's no progressive discipline. If your boss is going to fire you for a criminal code offense, like, no, we're not going to investigate whether he should have done something different. You broke your contract, you broke federal law, sorry, no EI. Right? 2 people that are arguably high on the job, or at least were high sometime around their job, but you're working on an oil field, you know, you're working with cranes and rigs and stuff. Obviously, if it doesn't matter what happened, you can't be using drugs. So no, it doesn't matter if there was no progressive discipline. So the key is in all 5 of these cases, the judge specifically used the words. I'll just pull a couple of examples up. That we don't have to consider how the employer behaved. And other similar statements, which is fair in those cases under those facts with the arguments that were made. It's completely reasonable for a judge to say, no, you broke your contract. In many cases, you broke federal law or provincial law, health and safety laws. We can't give you EI. And no, we're not going to investigate your employer. That's what they pulled out. The fact that they had 5 cases where a judge in those specific cases said, we're not going to investigate what the employer did. Now, obviously, the facts are very different from this. Their pleadings were different. The facts and the pleadings behind all 5 of those cases have nothing to do with the situation. But they found 5 cases where a judge said, yeah, we don't have to consider what an employer did because of misconduct. Now, I want to just lay an analogy out here. I think this is really important, this sort of thought exercise. If you're in a criminal court, right, and you're accused of something, you're arraigned, stand before a judge. If you say, I'm guilty, is there a trial? If you take a guilty plea, is there a trial?
No.
No. Why? You're guilty. You admitted to it.
Yeah, admission of guilt, exactly.
So if you admit to willfully breaking your contract or committing misconduct, EI misconduct, there's no need to investigate what the employer did, right? But if you're arraigned for a crime, let's say someone accuses you of robbery and you know you didn't do it, if you say not guilty, Your Honor, what's the very next thing that happens? Yeah, we're going to schedule a trial. Why? We have to fact find. We need to actually determine whether or not you're guilty of what you did. So imagine this scene where someone's accused of a serious crime. They say not guilty. And then the prosecutor looks at the judge and says, Your Honor, I've got 25 cases from the last 10 years where someone was accused of the same crime and they pled guilty. And those judges said, no, we're not going to have a trial because so for that reason here, we're not going to have a trial either. We're not actually going to investigate whether they broke the law, despite the fact the EI Act requires it. Why? Because I found other people who pled guilty in different circumstances to different things in the past, and somehow that's justification in the present.
It shows the collusion at so many levels, at so many different levels in all of this.
And it's been allowed to stand. That's why this has to be dealt with, right? The idea that you can find someone in the past 10 years ago who has nothing to do with you, who was accused of something that was legitimately a problem, and the judge said, yeah, we're not going to investigate the employer. To pull that out of context and say, okay, see, the case law says we cannot investigate your employer. Why? Because those people committed misconduct. You're accused of misconduct. So therefore, Misconduct means you can't investigate the employer, case law, put it in templates, and now anytime there's a misconduct, they cite these cases as justification for we're not going to do what the EI Act requires. We're not going to investigate whether or not you broke the law because they accuse you of misconduct.
Mm-hmm. Wow. Wow. I feel tired now.
Let me do one more.
This is just so saddening that this existed, that this happened. Give it to us, Matthew.